Hmm. एमती मारे से
देखो गोटे सर
ओपन कर दूची सेकंड ऑन केमती करिवे
एटी आस
एटी से ऑन कले Jai Jagannath. Good evening. Today is our fifth law lecture that is being organized by Orissa High Court Bar Association on the topic that execution of decrees in contemporary commercial laws. And today's chief guest is our Honorable Justice B.P. Rautray, who will deliver his speech on this topic. Now there is another big announcement from Orissa High Court Bar Association. Our Honorable Justice Sangam Sir is going to inaugurate the Orissa Premier League, a cricket tournament that is going to be organized among all the legal fraternity of comprising the entire Orissa association members, entire bar associations of Orissa. They will register themselves and they will be auctioned. Auction is going to commence on 13th of December, and the matches will start from 23rd January 2026, and the final will be played in our home ground, that is Barwadi Stadium, followed with the bar and bench match. Now, sir, I request our Sangam sir to please come along with our Justice B. Rautray sir and our President sir to inaugurate the OAPL. Please, sir. And sir, our Vice President, please. Sir, এইটা को click করি। OPL. আসুন।
You have to press it so
Sir, আপন ধরন সমস্ত ধরন। আগে।
মনে যাই ধরন। ধর। তো তুমি ধর। আরে এইটা তো সেকেন্ডটা।
আগে। ওকে।
এটা কোন রেগুলেশন লেখা আছে এটা তো?
আগে সেইটা।
ওকে।
সেটা ডাবল ক্লিক করো। স্যার সেটা।
হ্যাঁ, ধরো।
संजय महापात्र पड़ेला संजय
ওটা ফর্ম পাইছি ঠিক আছে ମୁଁ କହିଦେଉଛି
संजय
ফুল স্ক্রিন করতে
संजय महापात्र
Man, excellent.
से सब जिनसा थित रावल भेज एसेट
No, he is an asset.
There will be 6 teams which will be owned by 6 designated senior councils, and those names will be pronounced after another function, and it will be another grand inauguration. Now I request our guests to take their seats, please. So we'll be starting our seminar, the law lecture shortly. Thank you, sir. Now we come back to our 5th law lecture on topic execution of decrees in contemporary commercial laws. Now I request our President, sir, to start the opening proceedings. Thank you.
Thank you, Abhijit. Jai Jagannath. Good evening to all. First of all, I welcome all the members along with my Lord Justice Rautray, because my Lord Justice Rautray is coming to this occasion is really great, and he with his vast knowledge on this subject, he'll speak. He will deliver an excellent speech that is, and people are eagerly waiting to hear his speech. Not only that, also it is connected to YouTube. So people are will also our advocates and other persons will also hear it in the YouTube, and there is really it will be such very knowledgeable here. But I will also speak a few words about this subject also. Respected Honorable Justice B.P. Rautray, Honorable Judge of Orissa High Court, respected Honorable Justice Sangam Chau, who inaugurated this our OAPL, our Siddhartha Das, Vice President, High Court Bar Association, Mr. Abhijit Patnaik, Secretary and Office Bearer of Orissa Bar Association, and my learned brothers and sisters, we are all gathered here to for a discourse on execution of decrees in contemporary commercial laws. Actually, that is not a very subject, that is akin to the CPC, as I was discussing here. But since it is a commercial law, it's as if is a great thing. I was just telling my Lord Justice Rautrai about one experience which, because of short of time, I will not tell that experience share that experience with you. Let us start with the coming execution. The word execution is delivered from the Latin word ex sequi, which essentially means to follow out or perform. This term is not categorically defined in the CPC, but it is inferred from the procedures that it means enforcing or giving effect to an order or a judgment. It formalizes the rights and obligations of the parties. The legal framework for execution is primarily described in CPC, which describes several modes like execution by way of monetary payment, property delivery, and specific performance. And everybody knows the entire Order 21 is dedicated to execution. The framework for execution has been armored by rapid reforms through Commercial Courts Act, Arbitration Act, Insolvency and Bankruptcy Code, Mediation Act, etc. In addition to several amendments to CPC and the limitation in order to streamline the legal process, set timelines is dispute resolution in corporate commercial space and add efficiency in execution of decrees. In addition to policy reforms, judiciary is constantly endeavoring to in strengthening business confidence and delivering landmark rulings such as Sundaram Finance Limited versus Abdul Samad 2018. And I will request all of you to please read that judgment. It will enlarge your knowledge like anything. Rahul S. Shah versus Jitendra Kumar Gandhi 2021. See, Chamundi Moped Limited versus Church of South India Trust Association 24, etc. to boost the investors' confidence. Technological initiatives such as e-auctions, digital asset tracing, centralized bank attachment systems, and integration with land records in jurisdictions like Delhi and Maharashtra have reduced the average timeline by several months. But the technology and legislation alone are not enough. Actually, they have done a great job. Delhi and Maharashtra, they have done a great job on this issue, and they have reduced the penalty, the delay in the execution proceeding like anything. A decree is as every practitioner knows, is supposed to be the culmination of justice. But in commercial disputes, it often becomes the beginning of another battle. Of course, in normal civil proceeding also, the same thing is there. Unfortunately, the drag between judgment and real controversy has significant and economic moral cost. A 2024 Niti Aayog study estimates that nearly 60% decrease in commercial suits above 1 crore remain pending for more than 2 years post-judgment. It is not mere efficiency but has a significant bearing in credit inflow, substitution and ease of doing business. Of course, in arbitration proceedings in Section 36, we have seen that the execution proceedings are disposed of very quickly, because these normal proceedings, 47 and all these things are not there in the arbitration proceeding. So, India can take inspiration from jurisdictions like Singapore, UK and US. In the UK, execution post-judgment passage disclosure is compulsory, and freezing of charging orders, even ex parte, are routine tools. Non-compliance lead to swift sanctions, ensuring judgment debtors cannot simply outwit the system. Similarly, Singapore has developed a highly efficient examination of judgment debtor process where debtors must disclose assets under oath, and courts use garnish and seizure orders promptly. In the US, courts regularly allow some subpoenas, third-party discovery and turnover orders, sometimes reaching assets abroad. Actually, what happens when you are in the execution proceeding, when a judgment, the decree holder, because awards are decreased, treated as decrees. Commercial court judgments are also treated as decrees. So when you are executing decrees, of course, commercial court decrees are executed normally by following CPC. But Section 36 special in Arbitration Act, Section 36 special provided for execution of the decree, execution of the award, which is treated as a decree. So that actually we are at the last to understand, to know what are the assets of the judgment debtor. That creates a lot of difficulty. Unless it's a PSU, if the private companies, it's very difficult to assess. Therefore, even if the court directs them to file, at least I have got the personal experience in that regard. Even court directs them to file the affidavit regarding their assets and all that, they also create mischief in that. That is the reason why. So India too has made a remarkable strides in every recovery landscape through IBC. IBC is a really, if you go through the IBC code, it has because of the IBC, India now has recovered lot of loans from different defaulting companies, but lot of recovery has become very phenomenal. Perhaps the same model of time-bound judgment debtor creditor-centric enforcement can dispute execution reforms too. Similarly, effective is Section 36 of the Arbitration Conciliation Act in 1996, where an arbitral award becomes enforceable as a decree once time for setting it aside lapses under Section 34. In Orissa specifically, it is my suggestion to institutionalize specialized execution cells within executing court in synergy with Odisha's integrated revenue e-services, IRES and core banking linkages, ensuring timely execution and enforcement. So why I say so? Because if like we are specing special codes for different special offences, so if we create special cells or special codes for execution with decrease, then there will be less burden on the court and the execution will be faster. Declaration is not a mere formality but a true test of justice in action. The courts have reiterated time and again that post-decree inaction or delay subverts economic justice. It is high time that executions be reimagined as realization other than re-litigation. In normal civil court decrees, you will find that there are a lot of litigations arising out of this execution case. Of course, in commercial cases, the arbitration cases, it is less. Commercial courts, it is nothing, it is just like an alternative civil suit. The same thing will continue in case of normal commercial case. So now with this, I don't want to waste further time because my Lord Justice Rautra is an erudite speaker. He will speak on the, and also expert on the subject. So he will speak on the subject. So now welcome my Lord Justice Rautra to speak on the subject.
Thank you, sir, for your enrichment speech. It will definitely enrich us in our different legal facets. Now, sir, I call upon our chief guest, the Honorable Justice Bibu Rautray, to please come and to grace this occasion. Thank you, sir.
A very good afternoon to everyone. Sri Manoj Misra, President of Orissa High Court Bar Association, the Vice President Mr. Das, Secretary Mr. Patnaik, and other office bearers present, and all learned members of the bar present here. So today's topic, what I have been chosen to spoke is that execution of decrees and execution of decrees in contemporary commercial laws. Now, by passage of time, see, law has developed and law needs to develop for a prospering society. Law has to develop. So different commercial acts has come in force, and that includes mainly, as pointed out by Sir, Mr. Misra, President Sir, that the IBC Insolvency and Bankruptcy Code, the Commercial Courts Act, these are the main field in the commercial laws. So to understand these in the context of execution of decrees, so I will say that the provisions and chapter relating to execution in the CPC has no substitution. The execution has to be under the execution of decrees has to be under the provisions of the CPC. Section 36 of the Arbitration Act clearly specifies that every award shall be executed as if it is a decree. So execution of decree, that is under section, I think starts from 34 or 35 onwards. up to section 76 of the CPC. Sorry, excuse me, 1 minute. So before that, I will tell something that Commercial Courts Act 2015, it is enacted to expedite the resolution of high-value commercial disputes in India, introducing specialized courts and procedural amendments to the Code of Civil Procedure. However, the execution of decrees passed by these courts remains largely governed by the general provisions of Order 21 of the CPC, with no specific amendments introduced by the Act. However, as I heard that there was some proposal is pending regarding amendment of Commercial Courts Act with regard to execution of decrees passed by the commercial courts. Execution refers to process by which a decree holder. So, if you will come over to the execution chapter again, that execution means execution refers to a process by which a decree holder to satisfy the decree against the JDR or judgment debtor. Section 36 of the CPC, decrees from any civil court, including commercial court, are executed as per Order 21 of the CPC. And this uniformity ensures consistency but raises question about whether commercial decrees warrant specialized treatment for faster enforcement or not. Because the intention of the commercial court bringing the Commercial Courts Act is to make faster or to increase the pace of the civil proceedings. Therefore, I will focus on some provisions or some chapters in broad aspect to say the procedure for execution, the differences from general execution under the CPC, and the key features pertinent to commercial courts. Commercial court decrees. The procedure for executing decrees from commercial courts mirrors the CPC's framework under section 36 to 74, as the Act does not amend these provisions. Execution commences upon the decree becoming executable, typically after 30 days from the pronouncement of the decree. The decree holder files an execution application and the court issues processes to enforce the compliance of the decree. So regarding initiation of execution, the first application has to be filed in terms of Rule 10, then it will proceed accordingly. The form has been prescribed in the CPC. And section 38 speaks that execution lies with the court that passed the decree or a transferee court if assets are located elsewhere. Commercial courts, being the civil courts under the Act, thus retain the jurisdiction over their decrees unless transferred. So there is a decision I got of Kerala High Court where the dispute is whether the commercial court has the power to execute its decree or it has to transfer to the ordinary civil court. And I will refer to that decision in detail sometime after. There it is held that the commercial court has the competency to execute the decree of the commercial court. So where we generally refer the court which passed the decree as the original court. And if the decree is transferred to any other court, it is said as transferee court. Then coming to modes of execution, the CPC outlines several modes based on the type of decree, whether it is, in the sense it is money decree, decree in respect of a movable property, decree in respect of a immovable property, or a combined decree. And those key procedures include attachment and sale of property, that is elaborated under Order 21 under different rules. 30, Rule 41, 54 is the attachment, etc., etc. There is a provision for arrest and detention in the matter of execution of decree, and the provisions have been enumerated under Rule 30 to 40. Delivery of possession of the property or delivery of the property, that is Rule 31, 35, 36, etc. Appointment of receiver, how to execute against the firm, against the corporates, against the company, and the resistance to the decree as per section 40, 47, Rule 91 to Rule 97. And there is a most important aspect with regard to limitation in the execution. The limitation, as you all know, for filing the execution is 12 years as per the Limitation Act. But Section 5 of the Limitation Act gives a extended period of limitation on the basis of sufficient cause. So it applies, Section 5 of the Limitation Act applies to every proceedings except the execution of decree. There cannot be any kind of condonation of delay in the matter of execution of a decree. Suppose a party or a judgment or a decree holder did not prefer, say for instance, there was a decree for eviction. So the decree of eviction was issued in favor of the decree holder, but the JDR did not vacate the possession. The decree holder also does not prefer any execution within a period of 12 years. So what will happen? He cannot file the execution after completion of 12 years, and the delay cannot be condoned. So what he has to do? Either he has to go for a fresh suit, or the JDR can claim adverse possession against the DHR. So this is the most touching part of the Limitation Act with regard to execution of decree. The executing court acts ministerially but exercises the discretion even in the case of execution. And it can issue process like warrant, summons, and attachment, like what I have said earlier. And the procedure applies uniformly to commercial courts also in respect of commercial court decrees, ensuring enforceability of the same. There are some special provisions time-bound for disposal of time-bound disputes in commercial matters. to say it amends Order 5, Order 8, Order 9, Order 13A, Order 15A, Order 18, Order 20 to accelerate the pre-decree stages, such as limiting the written statements to 120 days and mandating judgments within 90 days. However, Order 21 remains untouched in the Commercial Courts Act. Therefore, it means that the commercial courts, in matter of commercial courts, the process of execution of the decree has to be under the contemporary provisions of the CPC. There is no specified provision prescribed for execution of decrees in commercial court decrees. Though there are some mandates in conducting the process of this suit under the Commercial Courts Act, but there is no such mandate under the Commercial Courts Act in respect of execution of decrees of the commercial court. So in conclusion, I would say in respect of the Commercial Courts Act, that the execution of decrees from commercial courts adhere strictly to the provisions under the CPC. And this uniformity ensures accessibility but undermines the Act's speed of imperative as evidenced by unchanged timelines and procedures. And so what has to be focused is the process of execution mentioned on the CPC. So I may not say the provisions in detail in respect of execution of decrees, where the CPC provides that section 34 regarding judgment and decree and 37 speaks of the court to executing the decree. Section 37 prescribes the definition of the court which passed a decree. So what is that court definition that passed the decree is? That means, as mentioned in the CPC, that court which passed decree, the expression the courts which passed a decree or words to that effect shall in relation to the execution of decrees, unless there is anything repugnant in the subject or context, to be deemed to include, first, where the decree to be executed has been passed in the exercise of appellate jurisdiction, the first court or the court of first instance, and second, where the court of first instance has ceased to exist or to have jurisdiction to execute it, the court which, if the suit wherein the decree was passed was instituted at the time of making the application for the execution of the decree, would have jurisdiction to try the suit. The explanation provides that the court of first instance does not cease to have jurisdiction to execute a decree merely on the ground that after the institution of the suit wherein the decree was passed or after the passing of the decree, any area has been transferred from the jurisdiction of that court to the jurisdiction of any other court, but in every such case, such other court shall have also the jurisdiction to execute the decree if at the time of making the application for execution of the decree, it would have jurisdiction to try the said suit. So, even after bifurcation of the jurisdiction of a court, after passing of the decree, the new court created would have also the jurisdiction to execute the decree. It is stated in one of the judgments of our court, 1973 1 CWR 648, that jurisdiction to execute it means and includes the competency of the court to entertain an application for execution, even if the court cannot effectively execute the decree for loss of pecuniary jurisdiction. It can entertain execution application and transfer to the proper court for effective execution. So the next important thing comes that the court, the next section 38, the court by which decrees may be executed. It is said that the decree may be executed either by the court which passed it or by the court to which it is sent for execution. For example, in Arbitration Act, the award has to be transferred to the civil court for its execution as a decree passed by the trial court. So even if the award is passed at Chennai, for instance, say the award has been passed at Chennai and the property situates at Ganjam, then the award has to be transferred to the court at Ganjam having the jurisdiction for its execution. A decree may be executed either by court which passed it or by the court to which it is sent for execution. It is very important. This expression makes it clear that an execution proceeding can only be filed before the court which passed the decree. If the property comes within its jurisdiction, and the execution of decree is nothing, it is in one of our court's decision, 1995 1 OLR, it is explained that execution of a decree is nothing but continuation of a suit to its ultimate finality, that is implementation of an order passed in a decree. Therefore, the valuation of an execution proceeding can be only the valuation of the suit in which a decree has been passed. Suppose a suit is dismissed by the sub-judge and it carried in appeal, and the appellate court grants the relief in favor of the plaintiff or the appellant therein and draws the decree. So where the decree has to be executed? Can it be executed in the appellate court? It cannot be. So as said, it has to be executed by the court of first instance. So the decree drawn by the appellate court has to be sent to the original court for its execution. Then transfer of decree. Section 39, transfer of decree. So what is the transfer of decree? The court which passed a decree may, on the application of the decree holder, send it for execution to another court of competent jurisdiction. Number one, if the person against whom the decree is passed actually and voluntarily resides or carries on business or personally works for gain within the local limits of the jurisdiction of such other court. Number two, if such person has no property within the local limits of the jurisdiction of the court which passed the decree sufficient to satisfy the decree, and has property within the local jurisdiction of such other court. Then number three, if the decree directs the sale or delivery of immovable property situates outside the local limits of the jurisdiction of the court which passed the decree. Number four, if the court which passed the decree considers for any other reason which it shall record in writing that the decree should be executed by such other court. So these are the eventualities where a decree can be transferred for execution to another court for these reasons, where the property resides, property situates, or the property in the original court within the limits of the original court is not sufficient, or there needs a delivery and the sale of immovable property situating outside the local limits of the original court, or for any other reason. These are the broad guidelines for transfer of decree. So as I said earlier, in the arbitration matters, the award which is sent for execution is nothing but a transfer of decree to execute it having the jurisdiction over the property. The subsection 2 of section 39 speaks that the court which passed a decree may of its own motion send it for execution to any subordinate court of competent jurisdiction. Subsection 3, for the purposes of this section, a court shall be deemed to be a court of competent jurisdiction if at the time of making the application for transfer of decree to it, such court would have jurisdiction to try the suit in which such decree was passed. Then subsection 4 says that nothing in this section shall be deemed to authorize the court which passed a decree to execute such decree against any person or property outside the local limits of its jurisdiction. So then the section 40 to 41 and the contemporary rules under Order 21 prescribes how a transfer decree can be executed. And the most important question that often arises in execution proceedings is section 47. So actually what section 47 mandates? Let us understand it. 47 says that questions to be determined by the court, the courts executing the decree. It says, all questions arising between the parties to the suit in which the decree was passed or their representative and relating to the execution, discharge or satisfaction of the decree shall be determined by the court executing the decree and not by a separate court. And not by a separate suit. Where a question arises as to whether any person is or is not the representative of a party, such questions shall for the purpose of this section be determined by the court. Explanation 1 explains that for the purpose of this section, a plaintiff whose suit has been dismissed and a defendant against whom a suit has been dismissed are parties to the suit. Explanation 2 speaks, for the purpose of this section, a purchaser of a property at a sale in execution of a decree shall be deemed to be a party to the suit in which the decree is passed. And second, all questions relating to the delivery of possession of such property to such purchaser or his representative shall be deemed to be questions relating to the execution, discharge or satisfaction of the decree within the meaning of this section. So this provision has been incorporated mainly to prevent multiplicity of proceeding. So a JDR can question the executability of the decree under this provision. It is held in 2021 OLR Supreme Court 1058 that the following ingredients for section 47 must be satisfied. Number 1, the question must be the one arising between the parties and the dispute relates to the execution, discharge or satisfaction of the decree. So these are three main things to maintain application under section 47. First, the question must be one arising between the parties. So as said earlier in section 15, who are the parties, it has been said. And second, the dispute must be relating to the execution, discharge and satisfaction of the decree. And it is well known that the executing court cannot go behind the decree. So the executing court cannot exceed the decree, what is directed. So what the executing court can do in case, to what extent? But the executing court can interpret the decree, but it cannot go behind the decree. Suppose there is an error in decree, whether the executing court can correct it or not. Whether the executing court can declare a decree as nullity. These are the most discussed questions arises. The executing court can interpret the decree, but within the limits of the decree. An error in the decree may be corrected, but subject to limitations. Within the limits, not it has a free hand. Subject to such limits, it can correct the errors. The executing court can also declare a decree to be nullity, but on certain conditions. The decree, when a decree will be nullity, if it lacks inherent jurisdiction or it lacks jurisdiction otherwise. So a decree can be said as nullity even by the executing court on the ground of jurisdiction, and that jurisdiction may be inherent, may be on the question of territorial or pecuniary jurisdiction or otherwise. is held in by Supreme Court in year 1993 that the executing court cannot go behind the decree unless the decree is a nullity. It appears there is a lot of confusion as to what is meant by decree being null and void. A decree is said to be a nullity if it is passed by a court having no inherent jurisdiction. Merely because a court erroneously passes a decree or there is an error while passing the decree cannot be called as nullity. The decree to be called a nullity is to be understood in the sense that it is ultra vires the powers of the court passing the decree and not merely voidable decrees. So there are different interpretations comes in practicality. So to determine the question whether a decree is in accordance with the judgment, this does not amount to going behind the decree. So as you know the definition of decree, judgment, order, etc. So the interpreting the judgment to get meaning of the decree cannot be said as going behind the decree. It is reported in AIR 1984 Orissa 49 that there are various types of jurisdictions. Number 1 inherent, number 2 territorial, number 3 pecuniary, number 4 personal. In case of territorial, pecuniary or personal jurisdiction, unless the objection is raised at the proper time, it may not be raised at a later stage. A decree passed by such a court lacking in such jurisdiction is not a nullity, but lack of inherent jurisdiction goes to the root and can be waived. So on the point of jurisdiction, as you know, the parties cannot confer jurisdiction on the court. Jurisdiction has to be by under the law. It is said in 1993 2 SCC 507 that the defect of jurisdiction strikes at the very authority of the court to pass the decree which cannot be cured by consent or waiver of the party. So the parties cannot confer jurisdiction upon a court either by agreement or it is the settled law, as you all know. On the question of executability of the decree, a declaratory decree is usually not executable. Simple declaration is not executable. It has to be practicality. The decree, in the sense, has to mention its practical execution. There are several questions always arise under this provision, either to interpret the decree or on the question of objection to the decree or the rights of the parties arising to be decided in the execution proceeding. And it is said in AIR 2001 Supreme Court 2552 that assignment, creation or devolution of suit property during pendency of the suit and such person acquiring interest cannot object the executability of the decree, but by separate proceeding he can show that the original party being no longer interested did not vigorously prosecute or colluded with the adversary, resulting in decision adverse to the party upon whom the interest had developed. The parties can also enter into compromise in course of execution proceeding. And this is the, I think, this is the main touching provision in the matter of execution of the decree. And I have left many things and many questions, many various types of questions arises within the scope of section 47 to be determined by the court. So at this time I leave up to you that whether a preliminary decree can be executed or not. You decide it. I will not say anything. The powers of the executing court for enforcing the decree, that is section 51. It is also an important chapter that speaks about the functions and powers of the executing court in relation to the decree. That includes appointment of receiver, that includes delivery of possession of the property, that includes attachment and sale, that includes arrest and detention, and that also includes any other such manner to be decided by the court as to satisfy the nature of the decree. It also says section 51 also gives right to the JDR to raise his objection to the execution of decree. And these provisions have been elaborately described in Order 21. Order 21, that is the longest order, containing 106 rules. And someone said in a lighter vein that if you need to fasten or need to increase the speed of civil cases, disposal of civil cases, the provisions under Order 21 has to be completely deleted. Section 74 that gives right to the party for resisting the decree. And now coming to Order 21. So Rule 11 speaks how to make an application. And very interestingly, you must know that an oral application can be made also as per Rule 11. Rule 11 says that where a decree is for payment of money, the court may, on oral application of the decree holder, at the time of passing of the decree, order immediate execution thereof by the arrest of the judgment debtor prior to the preparation of a warrant, if he is within the precincts of the court. And the sub-rule 2 speaks of the written application, how to make, what should be the contents, etc. The Rule 18 says execution in case of cross decrees. What is cross decree? How to execute? It says that where applications are made to a court for the execution of cross decrees in separate suits for the payment of two sums of money passed between the same parties and capable of execution at the same time by such court, then first, if the two sums are equal, satisfaction shall be entered upon both decrees. Second, if the two terms are unequal, execution may be taken out only by the holder of the decree for the larger sum and for so much only as remains after deducting the smaller sum, and satisfaction for the smaller sum shall be entered on the decree for the larger sum as well as the satisfaction on the decree for the smaller sum. Sub-rule 2 says that this rule shall be deemed to apply whether either party is an assignee of one of the decree and as well in respect of the judgment debts due by the original assigner as in respect of judgment debts due by the assignee himself. Sub-rule 3 says, this rule shall not be deemed to apply unless the decree holder in one of the suits in which the decree have been made is the judgment debtor in the other, and each party feels the same character in both suits, and the sums due under the decree are definite. The illustrations are very interesting. Illustration A says that if A holds a decree against B for rupees 1000, B holds a decree against A for payment of rupees 1000. In case A fails to deliver certain goods at a future date, B cannot treat this decree as a cross decree. And illustration D says, A, B, C, D, E are jointly and severally liable for rupees 1000 under a decree obtained by F. A obtains a decree for rupees 1000 against F singly and applies for execution to the court in which the joint decree is being executed. Then F may treat his joint decree as cross decree. So these are the some important provisions I am highlighting. I am not referring to all the provisions. The decree, the executing court has the power to stay. It says sub-rule 29 of order 21 says, rule 29 of order 21 says that stay of execution pending suit between decree holder and judgment debtor. It says where a suit is pending in any court against the holder of a decree of such court or of a decree which is being executed by such court on the part of the person against whom the decree was passed, the court may, on such terms as to the security or otherwise, as it thinks fit, stay execution of the decree until the pending suit has been decided. Provided that if the decree is one for payment of money, the court shall, if it grants stay without requiring the security, record its reasons for doing so. So the executing court has the power to stay the decree also. Power to stay the execution proceeding in certain circumstances. The next important, as I feel, is section 46, rule 46, that attachment of debt, share and other property not in possession of the judgment debtor. It includes the notice to garnishee also and order against the garnishee also. So rule 46 says that in case of a debt not secured by a negotiable instrument or a share in the capital of a corporation or other movable property not in possession of the judgment debtor, except property deposited in or in the custody of any court, the attachment shall be made by a written order prohibiting, number one, in case of the debt, the creditor from recovering the debt and the debtor from making the payment thereof until the further orders of the court. Number two, in case of the share, the person in whose name the share may be standing from transferring the same or receiving any dividend thereon. Number three, in the cases of other movable property, except as aforesaid, the person in possession of the same from giving it to over the judgment debtor. In 54, that is attachment of immovable property. The powers of the executing court have been described elaborately. Rule 54 says that where the property is immovable, the attachment shall be made by an order prohibiting the judgment debtor from transferring or charging the property in any way, and all persons from taking any benefit from such transfer or charge. Rule 1A says that sub-rule 1A says that the order shall also require the judgment debtor to attend the court on a specified date to take notice of the date to be fixed for setting the terms of the proclamation of sale. And order 2 and sub-rule 2 says that the order shall be proclaimed at some places on or adjacent to such property, blah, 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 blah. So that means the provisions regarding attachment of immovable property. And 58 also gives the authority to the judgment debtor, the court, to adjudicate the claims or objections raised by the judgment debtor or any other person. As you know that the provisions under 91 to 97 are often used in the execution proceedings. That Rule 91 says application by purchaser to set aside the sale on the ground of judgment debtor having no sellable interest. And 92 that speaks sale when to become absolute or to be set aside. 93 says return of purchaser's purchase money in certain cases. 94 certificate to purchaser. And 95 delivery of property in occupancy of judgment debtor. 96 delivery of property in occupancy of tenant. 97 is resistance or obstruction to possession of immovable property. And 98 is order after adjudication, and 99 is disposition by decree holder or the purchaser. These are often used to resist the possession or to resist the disposition. And section 1, rule 105 that speaks that the court before which an application under any of the foregoing rules of this order is pending may fix a date for hearing of the application. And it is like order 9, that where on the date fixed or on any other date to which the hearing may be adjourned, the applicant does not appear when the case is called on for hearing, the court may make an order that the application be dismissed. Where the applicant appears and opposite party to whom the notice has been issued by the court does not appear, the court may make hear the application ex parte and pass such order as it thinks fit. And 106 says for restoration of the application or setting aside the order under 105. And these are the provisions. As I have already pointed out that I have left many provisions, and some important provisions I only spoke of. In the matter of commercial court, decrees of commercial court, earlier I had said that I got a decision of the Kerala High Court that is pronounced on 5th of March 2025. It is the parties are MS Karthik Exports and others versus Krishna Kumar Agrawal and others. That the question was, a decree was passed the question was, I am reading out the judgment, please, some important paragraphs. Petitioners are arrayed as the judgment debtors, and the respondents herein is the decree holder in Exhibit P2 in execution proceeding number 52 by 2024, filed before the Additional District Court, Pathanamthitta. The execution petition was filed by the respondent seeking enforcement of an arbitral award under Exhibit P1 dated 23/6/2022. The sole arbitrator has held in favor of the respondent, and the first petitioner was liable to pay an amount of rupees 13 crores some odd to D. Mona Lisa Implex, the petitioner therein, along with the interest at the rate of 8% per annum, and the petitioner was also directed to pay an amount of rupees such and such to the respondent herein. An appeal was preferred by the petitioner challenging the arbitral award before the High Court of Calcutta, which is pending consideration. Meanwhile, the respondent preferred execution petition number 52 by 2024 to enforce the award against the petitioners, to which the preliminary objections were filed by the petitioners challenging maintainability of Exhibit P2 before the district court. Their major contention is that Exhibit P2 can only be filed before the commercial court and not before the district court. The district court has found in the impugned order that the execution proceeding before the district court is maintainable, relying on the decisions relied on by the decree holder in MS Beta Exim Logistics Private Limited versus MS Central Railside Warehouse Corporation Ltd 2023 KHC on line 195, which was in respect of filing of the execution proceeding before the district court relating to arbitral awards. Reliance was also placed on different other judgments, thereby analyzing the provisions of the Commercial Courts Act. It is finally observed that a reading of section 16 of the Commercial Courts Act 2015 would show that only a few provisions of the CPC are amended to suit a commercial dispute to a specified value to be adjudicated by a commercial court. A reading of CIDL would make it clear that what was intended by the amendment is only for the speeding up of the procedure of the trial of the suit and to pass a decree in a time-bound manner. The deliberate silence on the part of the legislature cannot be taken as one in which the execution power is not given to the commercial courts. It does not mean that Order 21 of the CPC does not have any application to the commercial courts to execute the decree. It is significant to note that if the execution proceeding had to be proceeded by the principal district judge, then a situation would arise where the court executing the decree of a commercial dispute as well as the court hearing the appeal would be one and the same. This is not intended by the legislature. Thus, a conjoint reading of section 36 of the Arbitration and Conciliation Act 1996, section 38, 47, 51 and Order 21 Rule 10 CPC and section 6, 10, 13 of the Act of the Commercial Courts Act 2015, it would make clear that the court which passed the decree, that is the commercial court, alone has the power to execute the decree and not the principal civil court of original jurisdiction. This is the ratio of the judgment. So the commercial court which passed the decree has to execute it as per the decision of the Kerala High Court. And with this, I would conclude that because everything cannot be, there are a lot of time will require, and everything and every aspects with relating to the execution of the decree cannot be discussed. Thank you everyone.
Your Lordship, in-depth and threadbare analysis of the different rules of Order 21, the execution of decree, is definitely a highlight of this function. Yes, sir. Lordship, we are very grateful and obliged that my Lord has educated us to this extent and enriching our knowledge to another level. Sir, with this, I request our Aston Library to please give a bouquet of flower to our Lordship. I request Abhishek to hand over a bouquet of flower to our President, sir. I request Jitu, our executive body, to hand over a bouquet of flower to our Vice President, sir. Now I request our Vice President, sir, to give the vote of thanks.
Respected Honorable Justice B.P. Rautre sir, respected our President Manoj sir, our Secretary Tutul, and all office bearers are present here. Senior members and learned members of the bar, my dear colleagues, younger brothers and sisters, I, on behalf of the High Court Bar Association and the entire legal fraternity, extended the vote of thanks to all the dignitaries, guests on the dais and of the dais for their kind participation and gracious presence to make the event truly successful. Finally, I thank you all. With these words, I conclude my vote of thanks. Once again, I thank you all. Jai Jagannath. Namaskar.
ସମସ୍ତଙ୍କ ପାଇଁ ବାହାରେ ଟିକେ ରିଫ୍ରେଶମେଣ୍ଟ ହେଇଛି ଆଳୁଦମ ଦହିବରା ପ୍ଲିଜ୍ ସମସ୍ତେ ଖାଇକି ଯିବେ।